Good morning, I'm Melissa Negrin-Wiener, Senior Partner at Cona Elder Law. Welcome to Mondays with Melissa. Today we're going to be talking about your living will. Now, first and foremost, your living will is not your last will and testament. Those documents are confused quite often. Your last will and testament is where you list where you want your assets to go when you pass away. Your living will has more to do with your healthcare decisions and your healthcare proxy before you pass away. So your living will in New York State really serves as evidence of your wishes regarding end-of-life decisions. And there are different types of living wills. There's one that might say that no matter what, I want all artificial measures taken to keep me alive as long as possible, no matter what my condition. And we are referring to artificial nutrition, hydration, respiration, being kept alive on machines. There's also a living will that says that if I have a complete loss of mental capacity, I'm no longer able to eat or drink without assistance, or I have a condition that's likely to cause death in a short period of time, and those first two items as well, that I don't want to be kept alive by machines. Now, in New York, this is not required language in these forms, so they can be altered. Perhaps in some cases, people will say, that they want to be kept alive for a certain amount of time, and then if there's no improvement, that the life-sustaining treatment can be withdrawn or withheld. The agents that are named in your living will must match the agents that are named in your healthcare proxy. So they have to be listed on that document as well. And the living will is really for your healthcare agent to have in their back pocket to help them make decisions if they're ever faced with having to make decisions about your end of life, and also for them to show what your wishes are if there's a family member or somebody else who may feel that you had a different opinion. So it's a very important document to have. Again, it is not your last will and testament. It is called a living will, and it is the third in the Advanced Directive series that we've been talking about for these past couple of weeks. It's important to note that if you don't have a power of attorney, a healthcare proxy, living will, that your family may be forced to bring a guardianship proceeding if decisions need to be made for you or if work needs to be done for you that no one has the legal authority to handle. So keep in mind these three documents that are quite simple in nature can keep your family from having to bring a guardianship and keep you from having someone put into place to make these decisions that you might not really want in the first place. So keep the decision in your hands and have your advanced directives prepared. Come back next week. We're going to talk about last will and testament.